Be seated. Good morning. We'll take the next case on the docket, Freddie Lawrence versus the state of Florida. Mr. Warren, you ready to proceed?
Thank you, Your Honor. Good morning, Your Honor. Good morning, Your Honor. Good morning. Raymond Warren out of Daytona Beach on behalf of Freddie Lawrence. I'd like to reserve 5 minutes, Your Honor, if I may, please, for rebuttal. The question I would like to pose to this panel is, how quickly can the human mind process information?
Did you raise
Undisputed?
that question? Did you raise that question below?
Your Honor, yes, I believe that's been argued as to when intent formed. And certainly the government argued it. And thank you for the pun on that one. It is undisputed that Mr. Lawrence was standing outside a club. How he got there is in dispute, but it was undisputed that he's standing outside a club. There are two individuals standing nearby. An individual inside the club says he sees an argument where Mr. Lawrence shoves somebody, and he closes the door. He doesn't see anymore until some indeterminate period of time passes, and he opens the door and he looks outside, and Mr. Lawrence is supposedly shooting downward. Gunshots do ring out. There are 4 people in the parking lot. 1 dies. Mr. Lawrence is charged. And 2 others flee. Those 2 who flee, one of whom is shot by an unknown gun. Bullet is not determined. He's running away from the scene. The other one indicates that the alleged victim in this case had a gun in his hand. He also testifies that Freddie Lawrence, when he first saw him, didn't have a gun, and then Freddie Lawrence walked away and came back with a gun. So there's an extended period of time, it appears, while Mr. Lawrence is standing outside the club. Gunshots ring out. How much time does it take for an individual to call 911? There's no question that an individual called 911. The recording is played. About 1 minute later, there are reports of additional gunshots, somewhere estimated by the attorneys at 6 to 8 shots. 1 minute. The medical examiner testifies that some of the bullets enter the body after death. Mr. Lawrence states that the alleged victim stands up from behind a car, raises a gun, he has a gun, he raises his gun, shots are fired. Mr. Avery testifies that a .357 Magnum, which is his gun, but he also has a .380, but he didn't have it that night, he claims, is thrown from the vehicle, that an officer sees it thrown from the vehicle, dispatching another officer to the scene to find the .357. The .357 has 3 expended rounds in the chamber, which Mr. Avery explains by him going to a weapons range earlier, not reloading the gun. But the .380 caliber gun that he says that he has is never found. Yet he's throwing one gun out, and an officer happens to see it, and that's the only reason why the one gun is found. The second gun was never found, but there's a .380 cartridge casing expired, expended in the parking lot. This cannot be rebutted.
But it can be
These are the facts.
But it can be rejected by the jury, correct? I mean, the jury is free to find whatever facts.
Well, our argument is the jury should never have gotten it, because he explained or provided a theory of defense that was unrebutted, and it should never have gone to a jury, because the government did not provide sufficient, competent, reliable evidence. They did provide inferences. Yes, he was angry afterwards. How much time does it take a person to reflect and process information? Somebody shot at him. A minute goes by. Is that sufficient time for him to form anger, to form rage, to form frustration, whatever it is? Individuals say he came in later, and the government is arguing that that's sufficient to overcome the inference that somebody stood up and shot at him when the physical evidence supports it, that somebody stood up and shot at him because there's a .380 cartridge casing expended that the government never tested. Their prime witness testified that he owned a .380, but he didn't have it with him that night. He's throwing a gun out of the car, which an officer saw, discarding evidence. And there is a period of time where nobody other than Freddie Lawrence knows what happened. Now, the individual who ran and who was shot through the leg, who was standing right with Freddie Lawrence, says, I heard gunshots, but I didn't see anything, and I turned and ran. Mr. Avery says, I turned and ran too, and I hid. I didn't see who shot first, but I saw the alleged victim with a gun in his hand beforehand. And I picked up a gun off the ground by his body afterwards. And the government cannot rebut that. The inference that my client was angry beforehand because he had a bloody nose is an inference. It's not a presumption, much less an irrebuttable presumption. The fact that he returned to the club and was angry and said, I'll put a cap in you too, in the fullness of time, that's an inference. It's not a presumption, and it's certainly not an irrebuttable presumption. And so the government wishes to pyramid inferences to overcome the fact that, one, gunshots are fired. A man calls 911 because gunshots are fired, and a minute later gunshots are fired again, and the death shot, the first shot, the only one that the medical examiner said that established where somebody was, established that the alleged victim was standing up. That bullet wound would have caused death. Now, they also argued a second one, which shattered the heart, would have caused death too, but that also was pre-death. But the evidence that Freddie Lawrence fired a gun later, 1 minute plus, however long it took to call 911, those bullets were fired post-death. And the government's basic argument was that he had a depraved mind because he fired at somebody who's lying on the ground. Shooting a dead person is not a crime. There is no case in Florida that I've found, and the government certainly didn't rebut that argument. You cannot kill a dead person. You cannot murder a dead person. You can mutilate a body, but you can't murder him. So shooting 10 rounds, 5 rounds, whatever, into somebody who's already dead is not murder. It's not second-degree murder. It's not first-degree murder. It's not manslaughter. Yes, sir. Yes, sir.
He was the only person who said that he shot in self-defense, right?
Yes. No one else saw anything.
So is it your position that in any trial in which the defendant testifies, as this one did, that he shot at somebody who died, that if he also testifies that he did so in self-defense, it cannot go to the jury?
Depending on the circumstances and I will concede that it does depend, the government does have to establish by competent and reliable evidence some form of rebuttal of that argument. But pyramiding of inferences does not do it. Having something stronger than having somebody mad 3 minutes later does not establish or rebut a self-defense argument. Nobody else saw it. The case law that I've cited established.
Didn't the evidence show that he went to the booth or whatever it was, got the gun, had to fight his way out because the bouncers saw that he was had a gun and was angry or
Well, that presumes that an angry person cannot shoot in self-defense. Really, certainly an angry person can shoot in self-defense. I apologize, Your Honor. I saw it was coming out of my mouth, and
No. I mean, he got hit in the face with a pistol. I mean, clearly he's
he has a bloody nose at the hands of the
There was testimony to that effect. It is contradictory, but I've got to concede that the testimony exists. But the question is does an angry person lose the right of self-defense in the state of Florida? I defy anybody to find case law to establish that an angry person loses the right to self-defense.
But he raises defense, and the jury evaluates it, and the jury says no.
He is the only one. This government has not rebutted it. It should never have gone to the jury. There's copious case law on that point, starting with the MacArthur decision. A person's explanation of what happens that is unrebutted by other evidence doesn't go to a jury. There's probably 5 cases in the brief that cite this particular point. I'm running out of time. The second one,
You are in your rebuttal time.
Right, I am in my rebuttal time. Yes. Issue number 3, Your Honor. This is where the government violated a court order eliciting testimony from the stand by a law enforcement officer after a judge ordered it not come in to establish that a SWAT team responded to a location 7 months later and that the officer had obtained a warrant for Mr. Lawrence's arrest. And then they began to argue flight. Where is flight? They never established that he was in the apartment and he left. He shows up, they say 3 hours later, and says, "I'm Freddie Lawrence, you looking for me?" Now, his testimony was he was out to eat. He left his apartment, went out to eat, came back, walked up to the officers, and they said, "Get away." He said, "What's going on here?" They said, "Get away." But when he heard his name called, he walked over and said, "I'm Freddie."
On what basis did the prosecution argue that the circumstances of the arrest were relevant?
They seemed to argue that there was some evidence of flight that made it relevant. My argument was there was no evidence of flight in this case. How does he even know that a judge issued a warrant? He's living in a place where they knew where to find him.
But
7 months later.
Didn't the detective testify that the defendant said he was watching the whole thing?
Yeah, he said he walked up and they told him not to.
No, I'm saying he said for a couple of hours he was watching the police at his apartment.
I can't state
the detective's testimony?
I can't state that my memory of the record is so complete that the detective testified that he's sat there and watched for a couple of hours, as opposed to him testifying that we were there for 3 hours and he walked up. And he said, "Well, I was waiting for 45 minutes because they told me not to approach the scene. So I walked up and I saw the officers there, and when I heard them call out the name Freddie, I walked up and said, 'I'm Freddie.' They arrested me." But that's notwithstanding the point. The government is arguing some evidence of flight when he was there. And secondly, the court ordered that it not come in. And you can't argue that evidence is inextricably intertwined if it's inadmissible to begin with.
Well, that's your argument under that point, right?
Yes.
That the order on the motion in limine was violated.
Right, and the state asked for a similar order, not bringing in evidence of outstanding warrants against the alleged victim, and the defense honored that order, but the state didn't honor, there were corresponding orders. There were 2 orders by the court saying, don't mention this.
Wait a minute. Aren't you mixing 2 things together,
No.
Counselor? The court order was based on a stipulation of counsel not to mention a warrant. There wasn't a court order saying you can't get into flight.
That is accurate. That is accurate. But there's no evidence of flight anyway. He was at the scene.
But that's not even raised in your brief, the initial brief.
The argument is they violated the court's order, introducing evidence in front of the jury, and then intermingled it with their argument of flight, that he was a serious criminal because a SWAT team was there and because the judge had issued a warrant for his arrest. And so they intermingled the arguments and makes the flight more egregious in that argument. But inadmissible evidence of a very prejudicial nature was placed before this jury, and now the government wants to argue, well, it was flight, when it wasn't flight.
You're down to
1 minute, yes. I better sit down.
Jennifer Moore on behalf of the state. May it please the court. This case is a case in which the appellant admitted shooting the victim. So the only issue for the jury to determine in this case is whether or not the shooting was done in self-defense. And whether or not the bullets matched and the guns that were found were all neatly categorized and found and matched up to each other is really irrelevant, because the appellant admitted on the stand that his bullet is the bullet that killed the victim. And his argument, once again, is self-defense.
He admitted that his bullet was the fatal bullet?
Was the fatal bullet. I mean, the coroner said that the bullets that were embedded in the body were all 9mm. They all came from the same gun. So there wasn't really a question about whether or not Mr. Lawrence killed him.
Was that the testimony, that they're all 9mm?
They were. They all indicated that, well, she only found 2 bullets inside the body. Some of them were through and through.
How did she describe them?
The
Did
coroner...
she say they were medium caliber or something like that?
I believe she said that they were 9mm. I'm not 100% positive about that, but she did testify that they were all of the shell case, all the 9mm shell casings found at the scene were fired from the same gun. So the big issue for the jury is whether or not this is self-defense. And it's the state's position that the state provided circumstantial evidence that was sufficient for a jury to conclude that Mr. Lawrence was not acting in self-defense when he shot the victim. And once the state introduces evidence that's inconsistent with his theory of the case, then it's a jury question to determine whether or not, you know, they believe what the appellant has to say or what other witnesses have to say.
All right, so it sounds like the issue boils down to, he says there was no evidence to contradict the
right.
testimony. And you say there was.
And the state's
so what evidence
the state's
are you talking
position
about?
is that Stephen McGinn, who was the manager of the bar, testified that he saw appellant pointing his gun towards the ground and firing it with an angry facial expression. Appellant says that he was running away from the victim, who was either waving a gun or shooting at him, and that he was shooting as he was running away without looking at where he was shooting. So his testimony is completely opposite to a witness who testified he saw him looking down over something and shooting downward.
What about the testimony, getting the gun from under the table or whatever it was? And
there was also
hiding his way
contradictory evidence. Some people testified he got it from the DJ booth. He admitted, he says he got it from the car out in the yard. But either way, he ended up with a gun in his hand. And whether or not the victim actually shot at him versus waving the gun around, you know, isn't necessarily relevant. What's relevant is whether or not the state provided any evidence that was contrary to what the defense put forth as their story of events. And Mr. McGinn's testimony did just that. It gave the court something inconsistent to make it a jury question. It became a question that the jury needed to weigh testimony, look at credibility of the witnesses, and make a decision as to how they believe that the case should go.
what about mentioning the arrest warrant?
I was about to turn to that. In this case, the officer testified that they went to appellant's house because they had an arrest warrant for him. An objection was raised, and it was sustained, and the jury was instructed to disregard it. So therefore, any error based on the remark was cured by the trial judge telling the jury to disregard that comment. All of the other information about the police waiting at the house for appellant...
Was there a request for mistrial?
No, there was not. All there was the sustained objection and the curative remark. And all of the information about the police waiting at his house and how long it took for him to admit that he was the person who lived there, none of that was objected to on the trial court level. So, you know, it's the state's position that that issue wasn't preserved for review. But it was also not a prior bad act or a separate bad act evidence. It was just a story completing the crime, explaining why, you know, how it came to be that appellant got into custody. But it
How is that relevant
it wasn't
to proving the offense?
It wasn't relevant to prove the offense, but it was giving the story of the circumstances.
But no objection was ever lodged.
But no objection was
On the
lodged.
basis of relevance.
It was completely irrelevant. In appellant's statement, he described it, to what happened to the officer, and he described it on the stand, and it was discussed numerous times throughout the record, and no objection was ever raised to that entire line of questioning. So it's the state's position that it wasn't preserved for review. The state respectfully asks that the court affirm appellant's judgment and sentence.
Thank you.
The appellant cited in his initial brief Ferguson versus State, and I believe actually this is in the reply brief. Ferguson versus State, 379 Southern 2nd 163, a third DCA opinion out of 1980, which involved a dispute with a bouncer that spilled outside of a nightclub. Nobody saw the shooting occur, but they opened the door later and saw the defendant running away. He came in and testified along with another eyewitness as to the facts of the case. The court indicated that this evidence should never have gone to a jury. Should never have gone to a jury. We must agree with appellant that because of the fact that the state had no witnesses to testify about the actual shooting incident, since it presented no evidence whatsoever to contradict the only two eyewitnesses' version of what occurred, and the defense's version is clearly reasonable, a clearly reasonable construction of the events indicating innocence, we cannot uphold the conviction on the charge of second-degree murder. Directly on point. Fight occurs inside a bar, spills outside, nobody sees anything. A second series of shots 1 minute later occurred. A person opens a door and looks at it. Another person's on the phone. That second series of shots occurred when the individual was already dead. That does not rebut his version of what happened, of a man raising a gun at him and shooting at him. The physical evidence corroborates it. It's a .380 caliber extended cartridge casing in the parking lot. The government never tested it. They saw fit never to test it when it was fired. Whatever they could have done with it, they didn't look at it. All they did is focus on 9mm ammunition. That's it. It was unrebutted. Thank you.